The popular saying that things can quickly change in politics practically came to life yesterday when, with less than 24 hours to his scheduled swearing-in as governor of Bayelsa State, David Lyon of the All Progressives Congress was disqualified and consequently kicked out by the Supreme Court of Nigeria. This followed an infraction of the electoral guidelines by his running mate, Digeremiyo. As a result of that landmark ruling, Senator Duye Diri of the People's Democratic Party will in a couple of hours from now be administered with both the oaths of service and that of office of governor of Bayelsa State. Well, we now have with us in our studios to react to this development, in Abuja studio, Kola Ologbondiyan, the PDP National Publicity Secretary, who will be joining us shortly. And here in Lagos, we have Liborous Oshoma, the head attorney of Liborous Oshoma & Co., and a judicial affairs analyst, of course. Liborous, welcome to the morning show.
My pleasure.
Good morning.
Happy Valentine.
Yes, you are not romance.
No, not really. I woke up this morning, it wasn't in my psychic. So.
And then in our Abuja studio, we have Kola Ologbondiyan. Kola, good morning.
Good morning.
Good morning, Dr. Ruben Abati. Good morning, Tudun. Good morning, Leila. And happy Valentine.
Yes, happy Valentine. Well, Kola Ologbondiyan, let us start with you. The last time you were on this program, after the ruling in the Imo case involving Emeka Ihedioha and Uzodinma Hope, we had told you, or we had asked you a question that, look, why is it that when PDP is favored by the judiciary, then PDP is happy, the PDP say, oh, the Nigerian judiciary is the best. But when a ruling goes against the PDP will say, oh, something is wrong with the judiciary. There's something untidy about this. This time around, I see that the PDP is very happy indeed. There were people jubilating yesterday in Yenagoa. But you have issued a statement. In that statement, you didn't quite celebrate the Supreme Court ruling. Instead, you are even asking for more from the Supreme Court, talking more in your statement about the Imo State ruling. And you want the Supreme Court to do more for PDP by reversing the ruling in the gubernatorial election of Imo State. How exactly does the PDP hierarchy feel about all of this?
Well, thank you very much, Dr. Ruben Abati. The issue of people saying that when the judgment is favorable, we rejoice. When it's unfavorable, we play on the intelligence of Nigerians by saying that, oh, the Supreme Court is not this or it's not that. It's just a game it's a game of the ruling government, and it's not the direction of thought within the leadership of the People's Democratic Party. But having made that clarification, for us in the PDP, we welcome the judgment on Bayelsa. However, the injustices, the misdemeanors that happened in the Imo governorship election must be redressed. They have to be redressed because they must not serve as a precedent for future election in this country. And Dr. Abati, you are a lawyer, and I know you understand the issues that the Supreme Court in its wisdom declared that Uche Nwosu had a ticket of two parties. That Uzodinma was never the candidate of APC. These were rulings of the Supreme Court. So we now wonder, as a party, how did Uzodinma, who was never the candidate of APC, suddenly became the candidate? How did he get votes? Because if you do not approach these issues and ask the Supreme Court to review the judgment, it would dent every other consequent elections in this country. And we say so because, one, Uzodinma was not a candidate of the APC. Two, Uche Nwosu was holding tickets of two candidates, of two parties. And you know it, that under the electoral law, as amended 2010, it's not possible for a candidate in the same election to hold the ticket of two parties. It's not possible. Then Uzodinma was not a candidate. He wasn't a candidate of AA. He wasn't a candidate of APC. He had no party. He was not in the election. Furthermore, if you look at the results that Uzodinma took to the court, It was formulated by him, concocted by him, and he just got a police officer to approve it. So what it means is that tomorrow, Dr. Abati, you can go and sit down in the corner of a buka in Agege and formulate results and look for a policeman to accompany you to court. Whereas the power, the authority to make declaration in an election lies in the Independent National Electoral Commission. This is the disposition of the People's Democratic Party. This is what we are seeing at. We must not allow these misdemeanors. We must not allow these discrepancies to be the basis of future elections. And that's why we are asking the Supreme Court to review the Imo governorship election.
Thank you, sir. Now to you, Liborious. The court's ruling, that bombshell yesterday, was predicated on anomalies in the form CF001 that was sworn on oath by Mr. Eremenyo, pardon me if I've butchered his name. Now, what can be done going forward? Because unfortunately, this is going to reoccur, I can quite imagine. This is a man who went from councillor to vice chairman of a local government, to chairman of a local government, who was a serving senator using these certificates. What should have happened? Is it that the party wasn't as stringent as they ought to have been, or was it INEC that should have stopped him when reviewing his certificates?
Yeah, basically what happened here is that by virtue of Section 31, subsection 5 and 6, it is the party who is alleging that these certificates are forged that will approach the courts. And so when he was a councillor and when he was senator, maybe the other candidate didn't deem it fit to challenge those certificates that he tendered. But when they submitted their nomination forms to INEC, the People's Democratic Party candidate felt that there were discrepancies in those certificates, and by virtue of that, approached the Federal High Court to challenge, those certificates, that the certificates were forged, that
but
the names...
Before your opponent decides to challenge it, does your party not have a duty to properly vet each candidate? Because
yes, it is that. With what the Supreme Court pronouncement had highlighted now is that the party should do a further and thorough job. Yes. Because before now, it was common for people to think that you could just regularize with an affidavit, which is what he did, a declaration. And so the court went further. The Supreme Court and the trial judge went further to say no, that even the affidavit, must be a proper affidavit, and that the affidavit that he deposed to, it cannot be verified, that the name of the notary public also cannot be verified. And then also, there ought to be the issuing authority in this instance ought also to be called to authenticate that this certificate we issued actually belongs to this person. Like you remember in the case of Barr, they had to invite somebody from Cambridge to come authenticate. But in this case, the certificates, according to the trial judge at the Supreme Court, all the questions raised by the plaintiff and the appellant in this as regards the names were not in dispute. They were all admitted. But the fact that they had cured those defects with an affidavit, which is what a lot of us do. So just go to court, depose on affidavit. And so the allegation was that this man, this certificate he's banding around are not his certificate. And he cannot, by mere affidavit, take ownership of those certificates. That was the main issue. And then the court so heard that truly, even the affidavit that is so deposed is defective in law. And so by virtue of that, you cannot. And it is also, the Constitution is very clear on Section 181, that if you tender is a forged document, and that the court has the power under Section 31, subsection 6, to disqualify you, and that is what it did. And so quickly, permit me, on the case of Imo State that Kola went to, I think he's missing the issues. The issue, the main crux of that matter should be, for PDP, should be the ground that Uzodinma did not meet the required spread as prescribed in Section 179, subsection 2. Because if they go with the issue of, Uzodinma is not a candidate, that was not the position of the Supreme Court in that judgment on Uwosu's matter. The Supreme Court said, Uwosu, you are alleging that you're a candidate of the APC and also a candidate of the AA. You can't be a candidate in two parties. On that note, they disqualified him. And so the Supreme Court did not say that APC. And so
well, he didn't say Owusu was
that's what he said.
Oh,
that's
really?
what he said. Okay. And so if you chase that rabbit, you'll miss it at the Supreme Court. But the main ground is that the man did, because even in the judgment of the Supreme Court, it is not stated anywhere. The Supreme Court just simply said he met the spread. I expected the Supreme Court to spell out the local government areas where he actually met the spread. That is absent.
Okay, so what we'll do now is we'll throw back to our Abuja studios. Mr. Ologbondiyan, if you can give us your response to what Mr. Oshoma has just said. And then also, I'd like you to comment on a controversy that has come up regarding this situation. The national chairman of the All Progressives Congress, Adams Oshiomhole, Comrade Adams Oshiomhole, has come out to also say that the PDP candidate, or Governor-elect Diri, cannot actually be sworn into office because he didn't win 2/3 of the votes in local government areas across Bayelsa. Is this true? And what is your take on this? But first of all, if you can respond to what Mr. Oshoma has just said.
The grant is not, we are not going to the Supreme Court asking for a review on one grant. The grant mentioned by the lawyer gentleman seated with you there is inclusive among the grants that we are taking to the Supreme Court. But I will not sit down, I'm not a lawyer, and I will not sit down here and agree with the objections that he had raised or with the points that he has raised, because these are issues given to us by the legal department of our party. However, the last point that he made concerning spread is also inclusive on the grounds that we are taking to the Supreme Court. But having said that, I believe that Comrade Adams Oshiomhole is the major architect of misfortunes of APC. And it is strange that he will come up and declare that nobody will be sworn in Bayelsa. As who or as what? Is he saying that the decision of the ruling of the Supreme Court will be subjected to another appeal in his own court of justice? Is that what he's saying? So for us, we had warned him as a party to stay clear of the issues in Bayelsa State. And he must restrain himself from creating a crisis situation, including a constitutional crisis situation in Bayelsa State. It should allow the judgment of the Supreme Court to be effected by the Independent National Electoral Commission. Adams Oshiomhole is not a staff of INEC. Adams Oshiomhole is not a chairman of INEC. Adams Oshiomhole is not a justice of the court, of the Supreme Court. So where is he drawing his strength to speak to consequence of the decision of the Supreme Court? Where is he drawing that from? So it is strange to us, and we have warned him. We believe that INEC will reconvene by 10 a.m. this morning to take a decision, and as we believe in the PDP that our candidate, Senator Diri, has met all the conditions required based on the judgment of the Supreme Court, and we believe that he will be sworn in.
Well, Liborous, let me come back to you. Now, I thought there was an aspect of Tundun's question earlier on that you didn't address about INEC. Does INEC have a responsibility to double-check the information that is submitted to it and to decide, even before the election, whether or not what is written on Form CF-001 is correct or not? And beyond that, now that it's been established that Berokuma Diego Perenyi, the man who has been disqualified, he swore on oath, right, on that form. The affidavit, you are also on oath. Is he likely to be charged for perjury? Or, you know, he has some kind of protection or privilege under the electoral laws that allows him to get away with perjury. And then third, the point raised by Adams Oshiomhole, yes, is the APC in a position, you know, to say that a Supreme Court order should not be obeyed?
Let me take them seriatim. Starting from Adams Oshiomhole, then I will. Adams Oshiomhole, I think he was a mere opinion expressed by a layman on a matter. And you know, in Nigeria, once the court delivers a judgment, everybody becomes a judge and a lawyer, chewing on it. Section 179, subsection 2 is very clear. And by the virtue of the Supreme Court decision in Zamfara, the position of the law is vote cast, valid vote cast. And so by virtue of that decision in Zamfara, when a candidate is disqualified, his votes are wasted. And so when votes are wasted, can they, in the eye of the law, be regarded as votes cast in an election? The answer is a no. And so if they cannot be regarded as votes cast in an election, for the purpose of reckoning of Section 172, subsection 2, then you can no longer be calculating those votes as vote cast in an election for determining to third, 25% of to third. And so what should be the determinant figures for determining to third is the figure from, you remove those figures scored by, those numbers scored by APC. And then you start from the highest to the lowest. And that's what determines, 1 quarter now. And the Supreme Court is clear on that. And that's why when people say, oh, no, the Supreme Court might need to explain further. And like they always say, we spoke English and not Latin. And it is clear enough. and so I think that Oshomole was not properly advised as at the time he made that statement. And if you ask him this morning now, he probably will not go on that same trajectory. Because, he would have been properly briefed and advised by his party lawyers now. And politicians, when it happened, even if Kola were in Oshomole's position, he probably would have been making the same statements. That's what they do. When it favors them, it is victory for democracy. Otherwise, they would, throw all kinds of stumbling blocks. And then to the next question of INEC. Before now, also, INEC could disqualify candidates until the Supreme Court heard that, no, INEC does not have such powers. These were party affairs. And that is only the court, by virtue of Section 31, that can disqualify a candidate. And so, to that extent, what INEC would do, after all the verification, they just, whatever report they have, it is for their use. They can advise the party if they so like, they want to. Otherwise, the verification becomes a mere paper tiger. And so in some cases, because what will be the essence of even verifying when you can't even do anything with it? So what they do, they just keep quiet and allow the opponents to do all the job. Even when they observe primaries, no matter how flawed the primary process is, INEC cannot do anything about it as heard by the court, that they don't have such power. That was why even in the case of Zamfara, INEC ordinarily had insisted that there were times for meeting, so you did not meet, the party did not meet the requirement, or that they did not meet the deadline. But it took the intervention of a candidate of the party to go to court to say, look, these actions should be nullified. And so what that did, INEC had complained consistently. And I think for fairness also, it is better for us to leave it this way, maintain status quo, allow the court to do the business of disqualification. Because if you leave it at the whim and caprices of INEC, and the day they don't like, you remember what happened in Atiku's case with Obasanjo, when Maurice Iwu was the chairman of INEC. He was almost like he was an appendage of the ruling party then. And that was why the court said, no, INEC, you do not have the business of disqualification, except, there are clear guidelines that the person had violated. And be that, what's the third question? I'm trying to remember the third question now.
No, I think you've
answered it.
You have answered it.
Okay. There was one other issue, quickly, I must mention this, because as at yesterday when the news broke, a lot of people were concerned why should Justice Mary Odili be on the panel? And that in the Buhari's case, Justice Bukachua was asked to recuse herself from that panel, and that Justice Mary Odili, being whose husband is a stalwart in PDP, ought not to have been on that panel. But they also forgot that 3 days ago, the same panel, headed by Justice Mary Odili, gave judgment in a similar matter, between Enikin Lokobiri and then David Lyon. Yes. And nobody complained at that time that Justice Mary Odili was a member of the panel. And also, it is not in the mouth of, beer parlor or social media, they are discussant. It is in the mouth of the lawyers in the matter.
Lawyers on social media.
So it is in the mouth of the lawyers in the matter to ask a judge to recuse herself in a matter because of conflict of interest. But in this case, that was not the position of the lawyers that handle the matter. In their wisdom, they know that justice would be served, and justice had been served. And so we should let it go and move on to the next.
Thank you, Liborous. Now, PDP is in a jubilant mood. I'm going back to you, Mr. Ologbondiyan. PDP is jubilating, but what is the mood of Senator Diri? Because he's not quite out of the woods yet. You still have some loose strings in the form of Timi Alaibe's petition. He is alleging anomalies in the party primary, saying that local government chairmen who were recently sworn in should not have been allowed to serve as delegates, that is contrary to PDP's constitution, and he's gone to court. So what are your comments on that?
Well, if you allow me, I will say the matter is in court and we should not go into it because it will become subjudice. But notwithstanding, I know that the party did what was right in the process leading to the party primaries. But we await the decision of the courts on the matter. But having said that, it's also important for us, and I want the lawyer gentleman with you to also, if possible, speak on this, that what we need in our country today is a holistic electoral reform. That the way and manner in which our elections are being conducted, they are fraught with irregularities and discrepancies. And that our protests to the international community is to draw the global attention to the misdemeanors that are happening in our country. And to also draw the international attention to the fact that our nation is dying. And they need to help us through their peer review mechanism, inform President Muhammadu Buhari that he needs to be proactive on all the promises that he made to Nigerians in 2015 and 2019. I also want to disagree with the lawyer gentleman that PDP is not just about being happy when judgment favors us. No, the People's Democratic Party is interested in justice. And because we are interested in justice, we want our courts to do justice and not engage in diabolical allocation of judgments. That is the position of the People's Democratic Party.
Liborous, quickly before we go, you want to respond to the questions he posed to you?
Yes. When politicians talk, you think they are talking from the moon. The PDP had the opportunity of righting the wrongs in this country for 16 years. One would have expected that all of the issues that they are complaining about now, that they had ample opportunities to set records. But they didn't do that. They set a very bad precedent. And so I put all of them, both the PDP and the APC, in the same bag. The APC is simply following in the bad precedent set by PDP when they were in office. And for me, the advice to APC is that, look, don't forget that, political office is like a tenured monarch. You behave like a monarch today, you leave office someday. And if you leave office someday, would you want to be complaining like Kola on the other end? That, oh, look, we are calling on the international community to come to our rescue when you had opportunity to rescue. For INEC also, this also calls to question the fact that our election should be determined at the poll and not in courts. If you allow processes to run seamlessly and transparently, courts will not have opportunity to begin to interfere. But when you leave everything to be determined by court, you are going to somehow affect the will of the people. Because if we say the election is the will of the majority, and then 5 people sit down somewhere, and whatever the will of the majority is, those 5 people will overturn it, then that is no longer democracy, but something else. And so that's why INEC should be up and doing in every election. Take the case of Hope Uzodinma, for example. I fought INEC in that matter because if you cancelled elections, you said you had 820,000 total number of registered voters, but you cancelled 25,000 votes. And Hope Uzodinma said there is a 333,000 votes somewhere that were not reckoned with. And yet, INEC in one breath said those are not the real votes. At the tribunal, we will tender the real votes. But yet, in the tribunal, There were no such result. And if you cancel the election, there's what we call Form EC40G. None of them were tendered. So if we continue like this, I bet you someday we'll just wake up and we'll discover that there's no country.
Well, thank you very much. Thank you very much, Liborous Oshoma. And thank you very much, Kola Ologbondiyan.
Thank you.
Thank you.